Hello, good morning Europe and good afternoon Southeast Asia. Welcome to our webinar entitled Protecting Your Brand in Vietnam, What Business Should Know. This webinar is organized in collaboration with the Southeast Asia IPR SME Helpdesk project and the French Chamber of Commerce in Vietnam. My name is Nora and I'm the project manager for the Southeast Asia IPR SME Helpdesk, and I will be today's webinar moderator. Joining me shortly will be Ms. Phuong Nguyen Dao, Business Consulting Officer of the French Chamber of Commerce, and our business advisor, Dr. Marta Bettinazzi. But before we hear from them, let's make sure that we all have a good understanding on how this webinar platform works. So throughout the presentation, we are looking forward to a lively discussion, so you can get in touch by typing in question in the question box on your screen, and we will be discussing your question at the end of the presentation. Also, please keep in mind that today's webinar is recorded and it will be available for download on our website shortly after the live session, and we will also share with you the link in a follow-up email after the webinar. Let's have a quick look at the agenda. So first, I will give you a very brief introduction to the Helpdesk project. After Ms. Phuong Nguyen Dao from the French Chamber of Commerce will introduce you the organization. After, we will move to the main presentation and discuss with Marta how you can protect your brand in Vietnam. And we will wrap up the webinar with a hopefully lively Q&A session. So let me give you a few words about the IPR SME Helpdesk project. This is an initiative of the European Commission to help European small and medium-sized enterprises to protect and enforce their intellectual property rights in or relating to Southeast Asia. All our services are free of charge. So on this slide, you can see the wide range of services that we provide. So for example, we have an inquiry helpline, and you can get in touch with us through this helpline and receive an answer to your IP question within 3 working days. Or you can also come to our office in Vietnam, in Ho Chi Minh City, to have an on-site in-person consultations with our IP business advisor. We also organize regularly training workshops and live webinars across Europe and Southeast Asia, which are tailored to the needs of European SMEs. Besides that, we also have a wide variety of IP publications on our website. So we have country fact sheets related to the 10 ASEAN countries, and also guides on various topics, of course, focusing on IP, but related to specific industry sectors or IP types and other interesting topics. For today attendees, I would recommend that you may want to check our IP fact sheet on Vietnam and our trademark guide. That could be very interesting for you. And last but not least, we also have some interactive learning tools, for example, e-learning modules that you can also access through our website. And without any further ado, I would like to invite Ms. Phuong Nguyen Dao from the French Chamber of Commerce to tell us a few words about the Chamber. Nguyen, the floor is yours.
Thank you, Nora. Hello, everyone. My name is Phuong Nguyen Dao, Business Consulting Officer of CCIFV. So for those of you who don't know much about CCIFV, we are part of the network of 124 French Chamber of Commerce and Industry and presented in 93 countries. So in Vietnam, since 1989, we've been working actively to promote trade and investment between France and Vietnam. Together with our 300 members, we are building a strong and dynamic business community, creating networking opportunities through various events organized throughout the year. So this webinar is also an example of the kind of workshop or breakfast talk that we host regularly. CCIFV also offers a range of business services for French and Vietnamese companies. For example, you are a French company, you are looking to expand your commercial activities in Vietnam by opening a representative office or setting up a whole new company in Vietnam. So you might need to get to know the market, the policies related to your business line, or maybe you're in search of the local business partner or a local employee. We offer all those services, from doing market study, to looking for the location to set up your factory, doing business matching, organizing business meetings. And to go back to the subject that Marta is going to discuss with us today about protecting your brand, our business support team, not me, but my other colleagues, this experience helping a French company to spot the fake products in the Vietnamese market. And we also identify the Vietnamese companies that commercialize the fake products. It wasn't an easy mission, and we understand fully the importance of protecting your brand in a fast-growing market. Please just bear in mind that you are not alone in this. Please contact the business community around you and look for help from experts whenever you feel the need. Now, without further ado, Marta will share with us her expertise and experience on the matter. Marta, over to you.
Thank you for your very interesting presentation. I think I will now show my screen. Let me know if it's ready. Sorry, can you see my screen?
Yes.
Okay, thank you, sorry.
Yeah, full screen, perfect.
Okay, sorry. As we said, we are aiming for a very alive presentation. So what I want to do is playing a simple game with you, a question and answer game. I would like you to look at the image on the right of your screen, this Nuevo Sangria, and I would like you to guess from where it's product. So now we will start a poll question, and you simply have to vote to decide, in your opinion, where this is produced. So we are now seeing the poll, and yeah, please vote.
I think we can launch the poll result.
Yeah.
So Marta, 38% voted for Spain, 23% for Portugal, 23% for China, 8% for Italy, and 8% for Vietnam. So who was right?
The right answer was Vietnam. But I'm interested that people put China anyway. That's a common misunderstanding in a way, that all the fake products come from China. But sadly, it's not true. Fake products are everywhere. This in particular, it's a production local in Vietnam. And the reason why this case is interesting is that this producer, this local producer called Lado Food, they are not just producing sangria, they are not just commercializing it, but they are also registering the trademark for sangria. At the moment, now that we are speaking, the registration is still pending, so we don't know if they are going to succeed or not on this project, so to say. But if they do, there will be huge consequences for all the Spanish companies trying to sell sangria in Vietnam, because depending the way this trademark is going to be accepted by the office, this company is going to be the owner of the sangria name. So every time you try to import something bearing the sangria name, you are at risk of a trademark infringer, to become a trademark infringer. So you that are the real producer of sangria from Spain can be considered here as a trademark infringer because you're using the sangria name. What is also important to notice is that sangria is in reality a GI, so a geographical indication. And in Europe, the pure name sangria could never be a trademark because it's generic. But here in Vietnam, probably the administrative office in charge of registering is not so well equipped regarding the production of sangria. So what can happen is that every company that wants to really import sangria in Vietnam have either to challenge this registration or to try to make an agreement with this producer, with this local producer. And by the way, if you are living in Vietnam, I'm sure you have seen this bottle in the supermarket. So this is the first case I want to present, but we have another game to play. Can you tell me what are you seeing on your screen? There will be a poll launched very soon. This Superman Choco Milk wafer. What is this? Now we launch the poll. Can we? Yeah.
So let's see the result. Okay, so 21% said A, the promotion for the new Superman animated series, 29% a copyright infringement, and 50% a perfectly legal use of the trademark by its Indonesian partner. So who is right?
You are surprisingly well prepared. The right answer is C. This is indeed an interesting story. Again, one of the horror stories we usually tell to our kids. There is this company based in Indonesia who registered the brand name Superman in Indonesia for food. Because another thing that is important to remember is that trademarks have categories. So you register for certain categories. And they registered in 1993, and they are doing something legal in a way. They are complying with the regulation. In April 2018, the DC Comics tried to challenge this trademark registration, mostly in trying to demonstrate that this is a copyright infringement because Superman is a copyright character. And they were also trying, meanwhile, to register their trademark for Superman. The result is that the DC lost the case and also lost in when they tried to appeal the decision. Why? Because if you don't register your trademark in Southeast Asia countries, Indonesia, but also Vietnam, are first to 5 countries. This means that the first person that is legally registering the trademark is the owner of the trademark, and there is no much regard of what could have happened in other countries. So if you have your trademark registered for 20 years in Germany or Italy or France or whatever, the US, is not so relevant. It could be taken in consideration if it's a very famous trademark, but the rule is what you are seeing on your screen. This is the official position of the Indonesia Institute of Science, that if the real keep in mind that the is calling it the real brand holder forgets to register their trademark in other countries. It's not impossible for someone else to register the same brand in Indonesia. So Vietnam in this is less, let's say, punitive. So there are more options for opposition, but still, you have seen the Sangria case. These are things that happen daily. What you can do to avoid this? So I hope I scared you enough, and now we try to look for solutions. First of all, it's important that you have clear in mind what are your rights, what is a trademark, we are going to see today, but also which other rights are part of your intellectual property portfolio. Learn how to register, of course, we are here for that. Register as soon as possible, and please keep in mind that as soon as possible probably means before you start doing business in a certain country. And then monitor for market infringements. This is something that we were hearing also from the CCIFV representatives. It's really important. There are a lot of organizations that help you with this, especially the Chamber of Commerce of your own country, that help you in this process. So even if you are not based in Vietnam, it's something you always have to keep in mind and keep an eye on it. So the first step, as I said, is understanding what are your rights. Today we're going to focus on trademarks, but just to have you understanding a little bit what is the framework we are discussing, there is also there are also other kinds of IP. Let's show all of them to have a look. Patent, it's something that protects inventions. This means, in other words, it can be a thing, it can be a process, it can be a computer-based invention, as long as it has a technical effect. So patent can cover a wide range of things, but it protects the ideas in a way, while copyrights protect expressions. We usually connect copyrights with the protection of artistic works. We are all of us familiar with copyright on music, copyright on television show, movies, etc. But copyright is also something that protects, for example, software or user manual that you are including in your package, or the content of your website. That the fact that it's on the internet means that it's going to be copied, but it doesn't mean that this is legal. This is not legal. If someone takes the image of your product and use it to advertise something different, they are committing an infringement of a copyright. Industrial design, it's very interesting because it's not just covering the classical product we all have in mind when we think about design, Vespa, Mocha in Italy, or the shape of the Coca-Cola bottle, this kind of stuff, but also the user interface of an app can be protected as design. Finally, the not registered kind of IP is the trade secret, which means basically you keep everything you are developing under a very strong bundle of agreements for secrecy, so non-disclosure agreements with your partner, with your employees, everyone. Also in this case, as for the trademark, patent, copyright, industrial design, we talk about register as soon as possible. When you are trying to keep something secret, the attention has to move to, you have to register, to have your partner signing a non-disclosure agreement as soon as possible. Okay, every time you enter a new market, a new contract, etc. So trademarks covers logo, branding, music, colors, etc. What's a trademark? Let's try to be a little bit more dogmatic. It's a sign that identifies a product. It has to be distinguished. It has to make the consumer able to see that this is your product. It belongs to you, to your company, not a competitor, not a copycat. It's yours. This means that you have to be very careful when you design your trademark, because you don't want to be the infringer in a way, and you don't want a trademark that is easy to copy. Of course, you cannot protect generic names, and for generic terms or descriptive terms, it means you cannot, you should not have a trademark like light for a company producing lights or lamps. But you can still have a company called Apple and make cell phones, because the level of this of descriptiveness of a term depends on the category. So you cannot call apples or Apple your fruit company, but you can definitely call it in the case I'm showing on your screen. Other things like offense to the public morality, public order, etc. These are rules that are common all over the world, but you have to be careful when you are facing a different culture, because they could find offensive something that is not for us. One clear example is the usage of the Buddha image in Thailand, which is strictly forbidden. So Vietnam doesn't have something so clear, so clear cut like this, but it's something you have to keep in mind if you are going to another culture. Let's have some examples. There are trademarks that are composed just of words, letters, and numbers. Those are the easiest ones. It's usually your company name or some version of your company name. But you can also register a stylized version of a word of the trademark. One example, Google. If you see this combination of colors, you are going to think about Google. Now they are updating it a little bit. I think it's the old version, but the concept is the same. You can use just an image without any wording, or you can register, which is better, you can register separately your image from your text of the trademark. One example, Hello Kitty. It's a very famous Japanese character. I hope all of us are familiar with it. And then you can have trademarks that includes both figurative elements and words, something like the WWF logo. Now we play another game, because I'm worried you are all sleeping in front of your computer today. So what I want you to think is, you see just this color. This color is a trademark or not? Can this be registered as a trademark? I'm discussing just the square, the color you are seeing. Can we launch the poll?
Let's see the result. So 43% said yes, it can be registered as a trademark, and 57% said no. Who is right?
And, sorry guys, you're wrong. It can be registered. The point is that the right answer will be depends, because the registration of a color trademark is something that is debatable, and in some jurisdiction is still not allowed. But I was asking a general question, and Tiffany will be disagreeing strongly with you, because they actually succeed in registering the trademark in 1998, and it's just the color. This means you cannot produce jewelry using this color for your packaging. Of course, it's limited, but still, it's a very strong kind of protection. One very famous also is Milka Lilac, but this, for example, is very discussed because there are other chocolate companies that have a similar shade of purple, just a little bit darker.
Marta, I think you are cut off. Marta, we cannot hear you now. Apologies, I think there is probably some difficulty with internet. Let's wait 1 minute. Marta, we still cannot hear you.
Can you hear me?
Yes, we can hear you.
Mm,
You move back to
I cannot hear you, girls.
how to register trademark in Vietnam? Yes, we can hear you.
Can you hear me?
Yes, we can.
Okay, I'm so sorry. I don't know what happened. So sorry. Can someone tell me where you stopped hearing me, Nora?
How to register a trademark in Vietnam?
Okay, the entire slide.
Yes, you
Okay.
stopped at the beginning of this slide. Thank you.
Okay. Again, I'm sorry for the technical difficulties. I have no idea what happened. So I was saying that I wanted to show you how to register a trademark in Vietnam, and this will be practical information. First of all, you should run a search for existing trademark, which means that you should check if you can, if your trademark is available or not. Because in case it's not, you should consider rebranding for the Vietnamese market. This kind of search is free of charge. You can do it on the website of the IP office, or you can ask us and we can do it for you. Then you have to actually file the application for your trademark. And the important part is that you don't need many documents. You need a good description of the trademark. You need to prove your ownership, etc. But the important part that many people underestimate is that you need to have everything in Vietnamese. So you have to make a translation and possibly an official one to have everything registered here. Then there will be a formal examination. So the examiner will check the formality of your application, and this should happen within 1 month. And after that, in the upcoming 2 months, your application is going to be published. This is very important. This is important because when the application is published, it is known to everyone, which means that if someone has a conflicting trademark or a trademark that they think is conflicting with yours, they can now oppose your registration. This is also important because you have to know that if you monitor who's registering similar trademarks, you will avoid to have problems in the future. So even if you have already done everything, you have already registered your trademark, you always should run a search to see if there is any possible conflict. Then the application, according to the law, should be substantively examined within 9 months from the date of publication. In reality, this usually takes 2 years. So when you are trying to register in Vietnam, you have to consider that it takes more or less 2 years. What are the fees? So how much it costs? The basic registration is talking of just the fees without the cost of the lawyer or the legal fees in general is 54 euros. And this allows you to register in one class. What are the classes? The classes are a classification of the goods and services. So for example, clothing or food. Usually it's better to register for multi-classes because it's better not to have someone selling similar goods under a similar trademark in a nearby class. So I don't know, food and beverage or retails, for example, is a different category from the apparel itself. So it's something to keep in mind. But as you can see, it's not an increase in the cost so significant. It's still an increase, but relatively short, so small. And then if you want to claim priority from a previous application, you can do that within 6 months, and it will be 24 euros for you to do so. This is the cost, and now we want to see a little bit why you should register. I mean, of course you should register because it's safer, you should register because you want to protect yourself, but you also can register in order to better exploit your product or your trademark itself. So what I mean is that you can license the usage of your trademark, or you can franchise, which is a little bit of a different kind of agreement, to have local partners selling your stuff or representing your companies, etc. This can be, of course, done because you cannot, I don't know, establish 10 shops all around Vietnam by yourself and managing everything, because it will be crazy. But this is not just because you cannot match the demand, it's also a way to get money. Basically, you get more money. Also, because you make money out of the licensing of your IP, of course. And you have to remember that when you operate in Vietnam, it's in some cases required by the law that you have a joint venture with a local company, because some enterprises cannot be run by foreigners. And in this case, and in any agreements regarding the IP exploitation, you have to remember some simple rules. One is not surprise at this point, you have to write your contract in Vietnamese, or at least having also a Vietnamese translation, because this makes the enforcement a lot smoother. And also you have to register your contract with IP Vietnam, otherwise it's not possible to enforce, or you, in some cases, you have a limited option for enforcement. So let's see what can get wrong. This is a case study regarding a European fashion boutique chain. They entered a contract with a local company to open an outlet. The contract originally gave to the local company an exclusive license of the usage of the trademark, which is quite standard actually. But the local outlet was breaching the contract, because they were not meeting the standards, they were not selling enough stuff, and they were also selling product of other companies in the same shop, which was forbidden. So the European company tried to see like how to adjust to this situation, like how to change this situation, and they discovered that the local company, as in a very smart way, decided to register the trademark under its own name for a different class. So the European company was owning the trademark for the class of clothing products, but not for retail. So in this configuration, the local company, the European company cannot find a new local partner, because for selling the product, that trademark was already owned by someone else, which was a previous partner. So at the end of the day, the European company started a litigation process, but it was advised to actually negotiate, because it would have been faster and probably easier to go out with a negotiation. The result is that they had to pay the former partner to get back the trademark of their own product, but for retail services. The lesson learned is that when you are drafting a contract with a partner, a distributor, or any kind of configuration, you should always have a very clear clause about IP, which is maybe will not impede the other person to breach your trademark, or breach the contract, but at least you have an easiest way to catch them. And when you're registering your trademark, as I was saying before, you should consider also the neighbor classes to avoid this kind of overlap or confusion. Of course, all this process costs a lot of money, like the process of buying back or claiming back the trademark requires a lot of time and a lot of effort and a lot of money. But let's discuss briefly about the enforcement, because I see that many people underestimate it. It's still an option, is there. So the best and probably the most cost-effective kind of enforcement you can use in Vietnam is the administrative action. There are different authorities you can go and try to enforce to have help to enforce your IP protection. I'm not going to give you the list now, but depending on the kind of IP and the kind of infringement, you have different options. The civil procedure is always there, of course, but it's very long and costly, considering also that conciliation or mediation is a compulsory process, which usually makes you waste a lot of time, because you should have already tried to negotiate in advance, and if it's not succeeding, there is a reason. It's important to have this option because it's one of the few options in which you actually get your money back. Because administrative action is very good to stop the infringement. Criminal action can also stop the infringement and also have a deterrent effect. On the other hand, civil procedure get you back the money. You can, in the criminal procedure, also became part of the hearing and request compensation for damage, but it's also a very long process. So in this case, it's not the most effective way, let's say. And finally, the custom protection, it's quite useful for counterfeited items that come from abroad or that you are sure that are coming from Vietnam, produced in Vietnam and exported abroad, because it's a block at the border at the end. And it's possible to register your trademark, so you teach the border police how to protect their how to protect your and enforce your trademark for you. So let's see what other options you have, because as I said, the litigation is not always the best choice. Also, to be honest, it's never your best choice. It's suitable for big infringement and when a lot of money is involved. Other options, less expensive for you and probably quicker, are communication from lawyers. It works quite well for the supposedly good faith infringers, so people that pretend they don't know they're infringing a right, so they usually stop by themselves. Negotiation and mediation, it's good when you are litigating with your business partner, so someone you don't really want to you want to lose as a business partner, because it will be easier to keep working together. And then there is arbitration, which is basically the equivalent of a court procedure, but with private judges, so to say. Please keep in mind that there are a lot of arbitration and mediation institution or regulation, like for example WIPO offers these services, also some Chamber of Commerce offer these services, so you are definitely not alone, and there will be someone there to help you. To wrap up all our presentation, and apologizing again for the problems, the technical problems, intellectual property is an asset, so it's something that has a value. It helps in building your reputation, strengthening your position in the market. It attracts investors, because investors are not stupid. If your trademark is not registered, if you have not patented your invention, you will get less money. That's definitely a thing. You can exploit, with the caution we have seen, your IP for the distribution sector to the production sector. etc. At the end of the day, intellectual property is money. And if you have to remember just one thing of all the things I have said today, is that registration is always less expensive than litigation. So register first, then we discuss. And with this, I think I thank you again for your attention. I apologize for the technical problems. And I'm here to answer your questions that please address to the question box in your control pen. Or if you are too shy, you can always write an email, but please participate.
Okay. Thank you very much, Marta, for the presentation. It was very insightful and interesting, despite the technical difficulty that successfully we managed to solve. And now I would like to open the floor for the questions. So still, if anyone has any question to ask, you still have time to type in. And in the meantime, there is one question about if a company wants to find out that another company may have already registered their trademark in Vietnam, how can they do it? Is there any way that they can check?
Yes, as I was saying, there is a data bank for that. It's powered by IP Vietnam. Is relatively updated, and it's also in English, even if it's probably not the best web designed website in the world, but it works. Also, you can use, if you want, some of the European and the WIPO data bank that if you want to cover more countries are usually faster, or you can ask us. It's the last option. I see some questions,
yeah.
right?
Yeah, I see. Yeah. So there is one other question on, could someone register a scent trademark in Vietnam?
No, that's sadly no, because basically untraditional trademarks like colors, shapes, 3D objects, and holograms and scents are not allowed for registration now in Vietnam. Now there was a reform, so some of them, like 3D objects, are now registrable, but the scent and the colors are still not possible to register. Maybe there will be a modification on this, but for the moment, okay, that's what we know.
Then there are very more questions. I think we still have a few minutes to discuss. So
yeah, I see many questions. I'm very happy.
What should companies do during the 2 years of Vietnamese trademark application process? What they should take into account?
So what they should do, the answer is not much. What they can do is that they could start their business since they have filed the application, because once the application is approved, it will retroact to the moment of the filing. So if someone is infringing meanwhile, you can catch them. This is, however, not the safest option, because it's still possible that for 2 years, while you are waiting for the registration, someone is infringing, and this can undermine your reputation, etc. But you can do that. You can start doing your business, and when your registration is complete, you go and catch them for infringement.
Okay, thank you. Another question is related to enforcement. How can IPB enforce on a business after termination of a contract? For example, setting up a technical system with a business that is a generic worldwide standard, but you have used it your own experience to make it easier.
I'm not sure I have clear, the case is completely clear to me. What I can say is that an infringement of your IP, because you have transmitted technology and they are now using, this is what I understand, you teach them how to do something and they are using it, not paying you any royalty or anything.
After the termination of the contract.
Yes. So this means that either they are infringing an IP you have registered. So, for example, you have a patent over that process or that technology. In that case, if you have a patent, you can sue them. Or if it was covered by a non-disclosure agreement, etc., this kind of agreement should be independent from the service contract you have with these people. So you can still catch them for breaching the secret. This is the other option. And then, of course, you can, it depends on the situation, but you can also sue them for unfair competition. If they are taking advantage of something you have taught them, and this is infringing your agreement and because usually you have also a anti-competition agreement in your contract. Is quite a standard clause, so you can try to go that way also.
And there is an interesting question. I think it would be good if we can also discuss that. If you are looking at exporting into various countries in Southeast Asia, do you have to register in all countries, or does one registration can cover the entire region as ASEAN?
No, sadly, there is no Asian trademark as for Europe. So you have to register in every country. What I will recommend at this point, if you're registering in more than 2 countries, that you consider to use what is called the Madrid system, which is an international registration system, which is not an international trademark. So it's not that you file that and you're covered everywhere, but it's an easiest way to file the application in every country, because you file one application and choose the country to apply to. So basically with one process, you cover more countries, up to 122, 23. I don't remember if 22 consider Malaysia, but among the Asian countries, 9 out of 10 are part of the system. So basically everyone except Myanmar. And you can use that system to register. If you need more information or a guidance on that, you can look on our website. We have a webinar on the Madrid system, or you can ask us and I can redirect you to where to find the information.
Okay, thank you. I'm very happy to see that we have a very active audience today, and there are a few more questions, so I think we can still have time for at least 2 questions. So, and the next question will be about how can companies register specific products, for example, medical drugs, and if this is the same standard procedure or is more complicated, though here is not specified for which IP type, but maybe.
Yeah, that's the problem, because if we have to distinguish the registration of a product that you need to import, for example, you need the code for import, etc., which is not an IP, it's an administrative procedure. And then for IP, it doesn't really, it depends on the kind of IP, it can be relevant or not, the kind of product. What I mean is, if you want to patent, then it can be very relevant which kind of product, which kind of invention you are trying to patent. Usually pharmaceutical patents are longer, to give you an example, because the in-depth examination takes more time for example, pharmaceutical product and for others. When it comes to trademark, instead is the same. You can name as many classes as you want, as many kind of products as you want, and it's not a big deal. Just remember that you have to register for different classes, and if within that classes you are selling more than 6 items, you have also to increase the number of items in your request. To make an example, if you are selling clothes, you have to register in the class of the apparel, in the class we have seen, but also you have to register, I don't know, like one thing is the t-shirt, one thing is the pant, one thing is the shoes, one other thing is, I don't know, yoga mats. So you have to remember that you have to name them. So that's the difference, but as for the procedure is exactly the same, as for this time is exactly the same. The difference again is within patent, kind of patent, but and then we can discuss patents, but it's different. Okay.
Yeah, thank you. It's clear. There is one practical question. I think you can quickly also answer that one. After the publication of the trademark, if there is no conflict, would it take up to 2 years? I understand the certification to receive the
yes,
certification.
the thing is, it never takes less than 1 year. 2 years is the maximum we, let's say, the most difficult cases, or but not necessarily because of an opposition, maybe because there is a conflict or other things, can go up to 2 years, but don't expect less than 1 year, 18 months. It's a problem because the office is slow. I'm sorry to say that, but there is a queue. So you queue with other people, and they process quite slowly the application. So yes, I would say not less than 1 year.
Thank you. And the last question would be, how common is arbitration for IP disputes in the case of foreign companies in Vietnam?
For what I know, for the information I have, it's common and quite used, but there's not as and probably better than a classical litigation, especially if you are European versus between quotes a Vietnamese. What I recommend though is to use not the arbitration in Vietnam, but try to have a clause for a more common arbitration hub, for example, Singapore, because this is the very cool part about alternative dispute resolution, is that if both of you agree, you could choose a different jurisdiction. And if you are dealing with, let's say, people in good faith, once the case is decided in Singapore under an arbitration, you should be able to enforce it. So yes, it's common and is increasing, and I would recommend it as a general rule.
Okay.
Better than try to go to a
Thank you very much. Thank you very much, Marta. And with this, we will close the Q&A session for this webinar. But if you have any other question, please feel free to reach out to the project, and we will reply to you by email to discuss any further concerns or questions that you may have. Marta, thank you very much for the presentation. It was a pleasure, and it was great to see that our audience was very engaged today. And I also would like to mention to today's webinar attendees that we will have another webinar on the 16th of April, where we will be discussing about moving manufacturing companies from China to Vietnam, and what are the legal aspects and IP considerations that companies should keep in mind. And on the 21st of April, we will have a webinar related to the Philippines, key IP tips when doing business in the Philippines. So if you are interested in any of these two sessions, please feel free to register. And I would like to ask Ms. Nguyen if there is any updates that you would like to share with the audience today with regards to the upcoming activities of the French Chamber.
Yeah, thank you, Nora and Marta, for this insightful webinar. I just want to say that, and thank you all for joining us today. In this difficult period, please stay strong, stay safe, and stay connected. And we see you all very soon in the upcoming webinar and events of CCIFV. Thank you all.
Okay, thank you, Ms. Nguyen. Thank you once again. Thank you very much for joining. And as Nguyen said, we wish you all very good health, and hope that soon we can also meet you at events and not only on online sessions. And thank you for today's speakers. Have a good afternoon.
Thank you, girls. Bye-bye.
Bye.